fourth panelist today is James Benjamin, a partner at the law firm of Akin, Gump. Prior to joining that firm in 2001, he served for over 5 years as a federal prosecutor in the United States Attorney's Office for the Southern District of New York, working as Deputy Chief Appellate Attorney, also as a member of the Securities and Commodities Fraud Task Force, and in his capacity as a federal prosecutor, he received a Superior Performance Award of the Attorney General. Prior to joining the Attorney General's office, the U.S. Attorney's Office, he was a law clerk for Federalist, so the District Court of Maryland, as well as for Supreme Court Justices Powell and John Stevens. Mr. Benjamin has more recently written, co-authored, I should say, a very important white paper published by Human Rights First entitled In Pursuit of Justice, Prosecuting Terrorism Cases in Federal Courts, some pretty exhaustive analysis of a lot of the legal issues that are proposed by that. Thank you.
Great, thanks very much. And to echo the other panelists, it's a real honor and a privilege to be here at this wonderful law school. I also think that regardless of anyone's view about the merits of all these issues, one thing that is an unmitigated plus about the discussion we're having is that it clearly is, holds the prospect for increasing public awareness and thought about how our criminal justice system actually works. And as maybe it's looking for silver linings, but I think that's often the case when we as a country face the most difficult and challenging political and legal issues. We all learn a lot about how fortunate we are to live under our Constitution and in a society that values the rule of law as ours does. I actually, in thinking about the topic, I more or less approached it exactly the way Professor Kelley did, kind of dividing it up really into two different questions. One, the title of the program is, Will Trying Suspected Terrorists in Federal Court Advance the Interests of Justice and National Security? I see that really as presenting two different questions. One, will it work? And two, is it a good idea? I think those are two really different questions. The first, there's no way to answer it with precision because, of course, we can't predict the future. But there's a heck of a lot of experience that suggests the answer to the first question. And in my view, it suggests that the answer is yes, it will work. The second, is it a good idea? Reasonable people can disagree about that. There are policy arguments on both sides. And Professor Flaherty addressed some of them. Vince addressed some of them. I'd like to focus on question one, will it work? Because there's a lot of the discussion by the prior speakers, I think, really is addressed to that question. There's no question that big Islamist terrorism prosecutions present very difficult challenges for our court system. There's just no question about that. At the same time, we have a lot of experience in handling these cases. As Professor Kent mentioned, my real background in this area is as the co-author of a 2-volume study, which I would recommend for anybody who's interested in delving into these topics more deeply, where, along with many of my colleagues at my law firm, we spent many, many months carefully delving into, first of all, trying to identify and locate, and then delving into and analyzing all of the terrorism cases that have been brought in federal court going back to the 1980s. And there have been well over 100 of them. And they came in all shapes and sizes. But a number of them presented serious, complicated trial management and other legal issues. Just to give a flavor of the kinds of cases that have been brought. World Trade Center 1 back in the early 90s. The blind Sheik case, also in the early 90s. The Ramsey Yosef trials, he was tried twice. First for his role as the mastermind of the World Trade Center 1 case, second for his role as the mastermind of the failed Bojinka plot to have coordinated airplanes blow up over the Pacific Ocean while they're en route to the United States. The embassy bombings trial. The Zacharias Moussaoui trial, about which I'll speak more in a moment. Ahmed Rassam, the so-called Millennium Bomber, tried successfully in Washington. John Walker Lindh, the American Taliban, captured in combat. successfully prosecuted in the Eastern District of Virginia. Richard Reed, the shoe bomber, in many ways very similar to the Fordham attack from just last month. Jose Padilla, held for many years as a purported enemy combatant, subject to a sort of a ping-pong match of litigation, military courts and the civilian courts, of habeas litigation, ultimately convicted after a trial in the Southern District of Florida. Al-Mari, very similar convoluted procedural path as with Padilla, the Al-Qaeda sleeper cell agent, who was a purported graduate student at Bradley University, but as the evidence ultimately proved was here at the behest of Al-Qaeda. Lynn Stewart, terrorism finance cases, the Holy Land Foundation case is one that comes to mind, successful prosecution in federal court in Texas. Many, many others. The statistics from those prosecutions are collected in our report. I won't go through them in detail, but the bottom line is the conviction rate, 91%, which is about the same overall as federal criminal cases. The sentencing data shows that defendants, as one would expect, are subject to severe sentences. Our study also looked in depth at the particular issues that tend to be presented in these cases. And rather than going through all of it now, because we don't have time, I'd like to just address some of the points that were raised by Vince, and in particular by Professor Kelley, because I think actually the experience and the law and the precedents provide ready answers to many of the questions that they raised, although I would note and emphasize that each case is different, and undoubtedly these prosecutions will present their own particular challenges, but just to address a few of them. First, Vince talked a lot about the risk of disclosure of classified information, sensitive information, sources and methods. Clearly, that is a serious concern in terrorism cases. But there's a method for dealing with that problem. And as some of the other panelists have spoken about, there's a statute, the Classified Information Procedures Act, which basically says that you need to, the judge needs to ensure that classified information is not released while the defendant's right to a fair trial is assured. And there is a careful process for making sure that works. And by and large, it has worked. We've had many of these cases, including a lot of the big, complicated, scary ones that I've mentioned, and there have been no documented leaks of classified information in any of those cases. There's one example that's often brought up, and Vince raised it earlier, of a co-conspirator list that was provided to defense counsel in the Rockmont case in the mid-90s. I can talk more about that in detail if we want, but it's one example. SEPA was not invoked, a protective order was not sought, and in my mind, one example in 20 years where the statute itself wasn't even invoked is a pretty thin argument if you want to look and say there's a real reason based on experience to think that security breaches are likely. It's actually quite an impressive record. It's also not accurate to say that there's automatic appeal rights to every SEPA issue. The government has the right to appeal if the judge makes a ruling that the government disagrees with. That's similar to the government's appeal rights on suppression motions and the like. Not to say that SEPA is easy, not to say that it's not cumbersome, it is, but as people who have dealt with it will tell you, it has a pretty impressive record of working. Another issue that Vince mentioned is, well, what about the problems of pro se defendants? And in particular, how do you manage classified information with pro se defendants? Well, the answer to that is very clear, and there's Second Circuit precedent on this point, there's Fourth Circuit precedent on that point. The defendant doesn't get to see the classified information. He just doesn't. That's what SEPA is there to prevent. So in the Moussaoui case, what Judge Brinkman did was she appointed standby counsel. And there's not an absolute right to self-representation. Ferretta recognizes that the trial court that has to have the ability to maintain proper control of the courtroom and trial procedures. And so standby counsel is appointed. And not just any standby counsel that can pass a security clearance. And standby counsel in the Moussaoui case looked at and dealt with the classified evidence. It's a similar procedure that was followed in another big Fourth Circuit case, Abu Ali, and it was followed in the embassy case, and the courts of appeals have consistently held that, of course, the defendant doesn't get to see the classified information. That would defeat the whole purpose of CEPA.